Good evening, everyone. Good morning, everyone in India, and good afternoon in Europe, and good evening in United States. We have a wonderful panel here today. We're going to talk about cross-border divorces. It's a complicated issue, and because it affects people's lives, people are very concerned where should they file the divorce in US or India. And there's all kinds of answers available that we'll share with you today. We have a wonderful group of panelists here with us today. I have 10-minute each of introduction for each one of the panelists, which will consume the whole session. So I'll just suggest each panelist to say a line or two about yourself. And I've noticed that when people do a self-introduction, they're able to cover their entire life in 1 minute. So we'll start with you, Mr. Nandgopal. You're on mute. You're on mute.
Yeah, Nandgopal from Bangalore with about 34 years of practice, and from 2007 a certified mediator at the Bangalore Mediation Center, and I have completely shifted from litigation practice to a dispute resolution practice where we look and try to help parties find a resolution to their dispute rather than an adjudication of their dispute, because I strongly believe dispute needs to end up with a win-win situation. Otherwise, there is always going to be rancor and disharmony in the society. This is very quickly about myself, and I'm a part of Law and Options, which is a full-service law firm, and we are based in Bangalore.
Wonderful. So, what is the divorce rate in India these days? Like 1% or 2%?
I would disagree with you on that. I would say that it is almost bordering about 27 to 30% is what is my perception is, because I think women's emancipation insofar as financial rights are concerned and the new laws that have come into force, women have become a little more assertive of their rights and what they're going to take and what they're not going to take, which is a very good sign in society, because it shows maturity of the society developing into a kind of a robust egalitarian society where everybody is equal.
Wow, that's wonderful. 27%. That's remarkable. That's reaching United States rates of 40% of marriage.
You see, if you look at it, we just have about 7 courts, divorce courts in Bangalore, which are chock-a-block full, which work on all the 7 days. And believe me, dependency is over 30,000 cases, which is certainly not a very good thing.
In Bangalore?
Yes, please.
I see. Is that where you practice?
Yes, sir.
Okay. Dhruti Kapadia, tell us about your life.
Good morning and good evening there. This is Dhruti Kapadia myself. I practice in Mumbai. I am an advocate and solicitor and advocate on record, Supreme Court of India. I'm also faculty with a couple of law institutes, and I love training people for different courses. Apart from that, I'm into counsel practice, wherein I like litigating, but matters like matrimonial, I prefer settling. So this is where I feel, the litigation should be cut down in such matters where emotions of human beings are involved, and the youth and the mid-age group people are involved who wants to live their life the way they want to, with the partner or without the partner. So this is what we keep helping our clients here for. The reason why I introduce myself more about matrimonial topic here, because I believe as a litigating lawyer, we don't want the disputes to immediately get disposed of. But when it comes to NGO, the mixed voices, our Milkar Desh Banaye, I work on issues of transgenders as well as law awareness programs. And more or less, I'm open for anything into policies because I hold my master's in public policy as well. So yes, I'm developing myself. I have experience of 13 years and I hope to look forward to have many more decades with me in my profession. Thank you so much.
Wonderful. Thank you for joining us. And when you say you like to settle cases, do you mean settle the divorce case outside the court or settle it that they stay married?
I will tell you, when I say settle, it means when the client comes to me, I want to read his or her mind. Are you ready to settle? If yes, I'll put it in my notice to the other side. If my client is willing to come on a Zoom meeting or on a meeting where they want to settle, is your client ready? If it is so, I'm very ready at the inception stage to settle it before it goes further. So it is either you sit on the table and you settle, or while we are arguing, if it comes from the court, why not settle? I'm always open for it.
Wonderful. Thank you. And finally, we have Miss Brenda Gandhi, Mumbai person that lives in Los Angeles now.
Good morning, good evening, everyone. My name is Brenda Gandhi. I was born and raised in Mumbai, went to law school in Mumbai. I was practicing in Mumbai for a few years before I moved to Los Angeles. Been practicing family law, divorce, custody, restraining orders for the last 10 years. And I work for Chugh LLP. We have offices all over the US and Indian affiliates in India. And I'm really excited to be here today. I think we're going to have a very interesting discussion.
Thank you, Brenda. Okay, so I'll just go around the panel and ask a question and keep your answers short so that we can cover a lot of questions, and then we can save at least 1/3 of our time taking questions from the audience. Okay, so the question we get asked often, I'll start with you, Dhruti. The number one question, so a couple of Indians have left India and gone to United States, and now they want to get divorced, and maybe one of them is back in India, or both of them are back in India, or one of them is in US. Where should they file the divorce, in United States or India?
A very good answer for this would be, let us understand the situation. If it is mutual consent, I would say it's better you file it in US if both the parties are staying there. But if it is contested, and if the marriage was in India and they have last resided, say, in USA, I would still say that if one party is willing to file it in India, let them do so, because if it is mutual consent, it gets difficult for the execution part of it here, because maybe the Indian courts may not really help so. So that's the reason it's depending on what stage of the divorce it is. Is it mutual or it is contested? And also whether a respondent is residing. Sometimes what happens is one party comes back to India, one party is in USA. So if he's the petitioner, it's better they file it where the respondent resides. But Indian law would be protective if they want to actually have a contested divorce file in India. This is my strong view on it. Okay,
wonderful. So, Mr. Nandgopal, first question to you. So currently, as you mentioned, there's a huge backlog. I'm actually quite interested to know, out of the 35 million pending cases in India, how many are family law divorce matters. Criminal are about 25%. But somebody even wrote a story that it'll take 466 years for India to clear the backlog, which means that the cases are stuck badly in courts. And I guess family law divorce is a matter that delay will cause severe harm to people's living and life and kids. So what are some dispute resolution mechanisms that you are using nowadays to resolve divorce matters?
Thank you, sir. Thank you it's a very interesting question. But what has happened in India is, especially, I can only speak of the state of Karnataka, is that any divorce matter which is filed by the parties is at the very first instance referred to what is known as a mediation center, where there are trained mediators who help parties try to identify their interest and try to find a solution to their own problems. The idea is, since it is a voluntary process, most of the parties we have, the Bangalore Mediation Center has a success rate of about 67 to 70%, 69 to 70% is the success rate in the dispute resolution mechanisms. So therefore, we are making an effort to see that these are curtailed. Since the resolution arrived at the mediation center, which becomes a part of the judgment decree, is non-appealable, we have effectively taken it out of the litigation or the judicial system. So this is one step which we have taken, but I'm sure that this is the same story in many states where mediation has taken roots of, especially in Bangalore, Delhi. I'm not too sure about how Bombay is working. But in Kerala, it's working great because I have been training in all these different states, so I can confidently tell you it is working, and the judiciary is taking effective steps into dispute resolution.
So you're saying when somebody files for a divorce in District of Karnataka, right away you are referred to a mediation center?
Very true, sir.
And in your
go ahead, please go ahead.
And in your experience, what percentage of the cases are getting resolved through mediation?
69%, sir.
61.
69.
69. Wow. Okay. So that's good. 7 out of 10 cases are getting resolved outside the court. And how does the mediation process work? Is there a judge involved?
No, there is no judge involved. The mediation center is manned by mediators who are lawyers who are trained as mediators. And the process is we follow the very same principles as since all of us were trained by people from the United States in conducting mediation. We follow the same principles of joint session, private caucuses, and therefore try to identify the interest of the parties and use the same principles and take it forward.
And the first mediation hearing happens within how many weeks or days or months?
Normally, the very first appearance of the respondent, the matter is referred to mediation. Normally, we have a 60-day window of opportunity to find a resolution of their dispute.
And who pays the mediator?
It is a pro bono, which is being done as of now. And most of the lawyers who are trained as mediators have put in at least about 20 years of practice, and they offer this service 1 or 2 days in a week, where they go to the mediation center and the center provides us the necessary infrastructure to take this dispute resolution forward.
Have you done mediation also as acted as a mediator?
Yes, sir. I've been a trained mediator from 2007, and I'm a part of the mediators trainer all over the country, and I'm still a very active person in the mediation center.
And you work pro bono at the mediation center?
Yes, sir. We do.
Wow, that's wonderful. That is really good to hear. Okay, some more questions for you regarding the mediation in a bit. Let me ask Brenda. So Brenda, so somebody is on H1 visa and the spouse is on H4 visa. What country should they file the divorce, US or India?
That's a good question. We get asked that very often. So it all depends on when the H4 is about to expire and how easily they can renew it. I personally don't think it makes any difference if you file it in the US versus India. But a lot of people who are on H1 and H4 believe that because they got married in India, they should file for the divorce in India. But that's not entirely true, because most states in the US accept foreign marriages. And it's totally okay as long as you meet the jurisdictional requirements of the United States state that you're living in, you're fine to file for the divorce in the US.
Okay.
Can I just ask a question here?
Sure.
Brinda, the biggest problem which most people have insofar as filing it in the US and in India during a mediation, what comes up is that if I file it in the United States, there is something called the marital property rights, that is the marriage property, joint property, which is alien insofar as Indian law is concerned, because Indian law identifies the woman's property as her separate property and the man's property as his separate property. There is no joint properties. Most of the disputes which I have had a situation or rather mediating, is this the biggest dispute that occurs. This is how we need to address this, something which I really don't know.
Yeah, that's a good question. So here's the thing, the US has 9 community property states, which means that at divorce, all assets and debts are divided 50-50. So yes, it would definitely be more beneficial to have and resolve and settle or litigate the case in the US, because I think as a woman, you'll always have more rights in the US versus India, and things are always more expedited here, right? The length of the case is not going to be as long. matters can get resolved in as little as 6 months to 1 year or 2 years, depending on the complexity of the case. Does that answer the question?
Yes, please. Thank you.
Okay, Dhruti, back to you. So you gave us an answer before where to file the case. Is there a special difference if one person has permanently moved to India and the other one is in the United States? Does your answer change as to where to file the divorce?
My answer would still remain, if you have to wait, it's more like forum shopping also, it could lead to it, because where I want to file. Like, for example, I am into a dispute, a tough dispute with the partner who is in USA, and I am now in India. I want him and I want to drag him here in India. And that's where I will use my legal acumen and I will use my options of this is the place I want to file, because he should now come and bear the expenses here. On the other way around, I would flip the coin and say, if it is mutual, it would be better you either do it in India or you either do it there. It's going to be sortable faster and it's going to be executable here if you're doing it in USA. So my answer would remain on what's your relationship with your partners and how quick you want the divorce. If you want to litigate and harass somebody, you always know in contesting divorce what forums we apply.
So how do the Indian courts look at it if one person is filed for divorce in United States and the other spouse is in India and they go to Indian court and file a case, and then the Indian court finds out that there is a case pending in US already? What is the reaction of the Indian courts?
See, that depends what kind of divorce petition, what kind of suit is filed. Sometimes they file restitution of conjugal rights. Is it possible for them to stay there? Sometimes the suit is filed, I mean, this petition is also filed for domestic violence. It depends case to case. So what exactly is the grievance? If you're a woman, we have a better choice here in India. I mean, in that sense, if you want to trouble your spouse, sometimes the law is misused. Let me be very honest about it. But sometimes the law is favored to protect the woman also. So it depends case to case, sir. So Indian courts would apply the mind accordingly and take it forward, in my view.
Okay.
Can I also take that question, sir?
Yes, please go ahead.
So I would like to put it this way, since I am also a practicing advocate. The question of jurisdiction is now more or less kind of getting itself merged in view of the fact that most of the courts have gone online. Excepting for recording of evidence, participation in the proceedings, the biggest threshold bar in any kind of a cross-border judgment and decree used to be that inability to participate in a litigation. If one were to see, the biggest defense that was taken is I am not able to travel overseas and I am not able to participate in it. So any judgment that is passed by a decree or a court overseas cannot be enforced in India. But in view of the fact that video conferencing is an accepted norm and parties can participate in a proceedings, the courts will be a little more circumspect. There is going to be a change in the approach is what my personal feeling is. I completely respect what Dhruti Kapadia is saying, but I think there is going to be a change because after all, we are all going online and digital and things are going to change. This is my understanding. That's number one.
Just chip in because what my learned friend said here, if I'm allowed to chip in because this is something interesting, it just tickled my mind because I've been doing a couple of matters in Mumbai. What happens is the online process is not very quick here. Because of the pandemic, people have just opened their eyes that yes, let's try to do the hearings through the technology. Let's be honest about it. There is also a problem of serving the summons. When the respondents are not accepting the summons, supposing in US or the whereabouts are not known, it is very difficult for the Indian courts to even proceed till the proper serving of summons is done. So that's where the other side staying abroad takes the advantage of saying, look, I'm not going to accept it only. I'm not staying here. I'm not working here. So a lot of those complexities come case to case depending on how the gravity of the bitterness lies between the parties and how they want to play with the laws that's available for them.
Okay,
like
great. So, Mr. Nandgopal, we were talking about the mediation. Very happy to hear that 70% of the cases are getting resolved. So, real quick, how long would the mediation process take generally? 6 months?
Normally, the 60 days is the window of opportunity. If in 60 days the matter is not resolved, the matter is sent back to the court, which is normally used as the leverage to get parties to find resolve 60 plus another grace period of 30 days. So it is 90 days is what one can look at. If realistically parties want to find a resolution, they do it within that first 60 days or maximum in 90 days time.
But is that really enough time if there's properties and Bangalore houses are expensive? Is the property, there's kids involved, alimony, child support, everything settled in 90 days?
See, the thing is like this, sir. Insofar as alimony and the division of property is concerned, it is quite very simple. It can be done because they will enter into the settlement saying that, look, this is A, B, C, D, E, F, G, which is going to be done on the day, the moment the decree is passed. So normally it becomes an enforceable decree. So that is one good portion of it. Insofar as custodial battle is concerned, if parties are at loggerheads, normally the mediator will encourage them to at least resolve the disputes which they can, which means the divorce, and the question of custody can always be left open for the courts to adjudicate in a separate proceedings. Normally, we reduce that to a much smaller jurisdiction, which over the period of time, after all, by the time the child is 15, the child can choose which parent it wants to be. So it kind of peters down to that, and ultimately the dispute is resolved.
Okay, and if it's not resolved, the other 30% of the cases, how long is that taking?
So, well, that in some cases, unfortunately, due to the current pandemic, we have had a backlog, but otherwise it takes about a year or so to resolve in the family courts.
All right, and is there a law in India or in theory or in practice that if it's a normal marriage, normal divorce, and a long-term marriage, then the property will be split 50-50 or no?
No, sir, there is no such thing. Only the question of Section 26 of the Hindu Marriage Act only says that there should be adequate amount of alimony that should be provided. The court can decide on what is the quantum of alimony depending upon both the income of the spouses and the financial status of the spouses. The court will have to decide what is the quantum of alimony. Of late, the courts have been fairly liberal, and I don't think there should be an issue insofar as that is concerned.
And what if they have two houses and each one is worth 1 crore? Is it split one each or no?
Sir, that you are calling for an adjudication. Normally, parties resolve the dispute saying, you take one, I take one. That's how it is resolved.
Okay. But left to the judge, is the judge going to try to do a fair split of the property or? Favor?
He will normally try to. What he will do is if they don't agree on the property, then he'll fix a fairly large sum of money as alimony. So if that is going to be a threat, well, parties to find a solution and they will come to some kind of terms.
And if there's two young kids, is there an automatic bias that the mother will get the kids?
No, sir, I don't think so. Because the court ultimately decides who is going to be the better parent. There are cases in which custody has been awarded to the father. There are cases in which custody has been afforded to the mother. It is a split between the two. Okay. And sometimes even to the grandparents, because if the court finds that the parents are not the most congenial people, sometimes even to the grandparents if they do apply.
Okay. All right, wonderful. So Brinda, the question we get asked in the US the most is, unfortunately, I'll be a little sexist because that's majority of the times. The husband is a software engineer, comes to the US on an H-1 visa, and then goes back and gets married and brings the wife on a H-4 visa, which is a dependent visa, dependent on the H-1, and then they have a marital problems. And so we get calls generally from the wives saying, hey, what do I do if I file for divorce? Will I lose my H-4 visa? Do I have to go back? Should I file for divorce or should I keep quiet and stay put? What's your advice?
Yeah, that's a question we get asked really often by most women who are on H-4 visa. So here's what I want to tell them, that H-4 visa is not your only option. You have a bunch load of other options like the H-1B visa, the U visa, the VAVA. You can have the option of extending your visitor's visa. You can also apply for a work permit. You can also apply for a student visa. So there are a lot of options. And to answer whether we should file for your divorce or not, or wait, It depends on the facts of every case. I like to know facts of every case, and then I decide whether I should file for divorce or drag it out so that I can give them some time to adjust their immigration status. And we've done that in a few of our cases. So they have a lot of options, Navneet.
Okay, wonderful. So Dhruti, many years ago, we were involved in a divorce matter in US, and all of a sudden we get some mail from Chennai saying that the wife has filed for restitution of conjugal rights and the judge is gonna order the husband to go back to the wife. I could not believe it. I couldn't believe that such a law would exist anywhere in the world where the judge is saying to one spouse, go back home and stay with your spouse. But anyways, I read about it and I understand that's the law in India. Is it still prevalent? Do people actually do it? And can you tell the audience what is restitution of conjugal rights?
I will be happy to explain this because if you are sitting on the dais to decide about the restitution of a conjugal rights, first point, as a lawyer, we need to know, can we actually file it? Is it reasonable enough that you're going to ask somebody in US to come and stay with you here? Because why has he withdrawn? Maybe he's withdrawn because he's got a permanent job there, perpetual option to live there. Then in that case, if I'm going to file something like this here, it's unreasonable, because court will definitely not apply the mind to give it to us. But if it is the case that he is desperately for a temporary period just gone there just to harass somebody or just to make sure that, you know, she suffers something or he suffers something, if a wife does that, is both the ways, it's for both the spouse, then in that case the court will see the reason of withdrawal and why is it necessary that they should not stay together, or why is it necessary that they must stay together. What is restitution? I will now first come to this. Restitution of conjugal rights means as husband and wife, we ought to live like married couples, and you need to perform your duty as a husband. I need to perform my duty in complete sense as a wife. And if one is abandoned by the other or one is withdrawn by the other in front of the society, that is where the petition needs to be filed. And I want my restitution rights to be given back to me because I'm not getting all the satisfactions of a man or a woman who ought to live with me in every sense. So what happens in that case, the court will then testify. Why is this man not staying with you? Or why is this woman not staying with you? Has she just gone right now? Or from how long has she deserted you? Or from how long has he deserted you? Then the answer comes that no, from 3 years he's doing a job in USA. Then now why are you filing it today? I mean, when he's already going on a job there, you already know the period is gone. But if he's going to fly out and leaving her like this, then in such a situation, as you answered, as you gave your example, it is possible the court would say, no, this is something wrong you are doing. You must come here and first perform your rights. So case to case, it will vary. It would depend on the intent and why is this done? Is it done for the reason, the withdrawing of the spousal relationship? Is it done because you are doing this because you want to get a divorce, or you want to pressurize the other side, or you're doing this because it is genuine for you to go there? So that is upon the case-to-case theories of it. In most of the cases, I would say, though the wife or the husband doesn't want to get this restitution, but because one party has filed a divorce petition, they're like, no, now just to counter it in the reverse sense, I will say restitution, because she will not take me in and he will not take me. I'll also do it this way. So it is the intent. Why are you asking? Do you really want to give your marriage a second thought, or do you want to really save it? Do you really want to be with him or her? That is where the courts will have to apply their minds, in my view.
Wonderful. I wonder if the Indian Constitution has a line that everybody is free to live however they want to live, and I wonder if restitution of conjugal rights is unconstitutional in some way. But interesting.
It's more like a pressure on the other side, just saying that, look, you have to forcefully live because you don't want to live with me. You have decided that you've gone out of my house, or I've thrown you out of the house, for example. So because now that you will suffer these miseries, that till you don't sign this divorce paper or till you don't come for a mutual settlement, then let's suffer these miseries of it. So moreover, it's a play of the mind. Nobody wants to, in a dispute, live together in honest sense.
Right.
I just want to add one thing, sir. Most of the times in India, which we see is the moment the woman goes to the court, like what Jyoti was saying, that abuse of the process of law, the moment a woman goes to the court, first a petition is filed under the Dowry Harassment Act, then a petition is filed under the 498, the Domestic Violence Act, then 498A, which is dowry harassment, and then along with it, a petition for restitution of conjugal rights is also filed. Now, it defies logic as to why a person who is supposed to be so abusive that the lady wants to go and live with him. It is just a classic example of what is known as the abuse of the process of law. Further, to this, many a times when courts do grant the restitution of conjugal rights, it is the most unenforceable portion of the judgment you can ever think of. Nobody can ever force you to live with a person whom you don't want to live, and the courts cannot come and supervise. It's a kind of a ridiculous piece of legislation which has stood in the statute books, and everybody is exploiting it. It is like, if you really look at it, the marital laws in India is a paradise for lawyers. The amount of litigation that one litigation can drive into half a dozen litigation, and to couple with this, they also file a proceedings under the Criminal Procedure Code. Here, many a times I find the spouses are extremely successful, well suited and everything. They will file a petition for maintenance under the Criminal Procedure Code for as paltry sum of, let us say, 5,000 rupees, 2,000 rupees, just in order to harass. So, the thing is, when you really look at it, it's a very unfortunate situation because we are not able to address the interest of the parties. All this is because of the interest of the parties.
May I just add something to what Sir just said?
Please.
Sorry. Because this was something which catched my mind because I've been doing this in one matter. One guy just filed a petition of divorce. He got an ex parte decree. A foreign from a different country goes ahead and says, this is ex parte decree I'm filing, and therefore now I'm coming to Mumbai and entering your house and staying in. He breaks in the house, she breaks in, and then she's not ready to go, and there's a status quo order which permanently goes on and on and on and on, and poor guy has suffered because he filed a divorce petition. His own property is with somebody else today.
That's true, very true.
And this is really happening, sir.
Sometimes I feel the Indian judges are too lenient, and they should be handing out harsh punishments of money to lawyers who do all of this, and that money should be used to make the courts better.
At the risk of being called contemptuous, I will say most of the Indian judges, be it a lady or a man, they're extremely patriarchal. They always think that they know the best and they need to be the parents to the litigants. That is when the problem arises. I have said this in many symposiums with the judges present. Stop being patriarchal. Let parties decide what they want the best. You are not here to decide their rights because they didn't ask your permission to get married. So let them, if they want to separate, let them separate. Why do you need to be patriarchal? This is a constant conflict I have with these judges when I talk to them in the symposiums. But let us hope that sometime some things will change.
And I think there's not gender judgments, because when you're appearing for a man, there should not be comments coming forward. As a woman, you are arguing this. That should be stopped.
I agree with you. I agree with you. It has come. It comes. I agree with you.
Navneet, can I add something here about what US courts think about restitution of conjugal rights? They just laugh it off because it's unconstitutional in the United States to force somebody to go back and to force them to be in a dead marriage, because everyone has a right to marry according to the Constitution of the United States. So they just laugh about it, they ignore it, because we've had cases where one party filed for the divorce in the US and the other one flew down to India, filed a restitution of conjugal rights, and the US judge really doesn't care about this. And then we're, going ahead with the proceedings in the US without any regard to the restitution of conjugal rights. And I completely agree with Nandgopal, sir, whatever he said is accurate. It is a useless piece of legislation that does nothing.
Right. But, it's India, right? What Nandgopal said about patriarchal, that the judges feel or the courts feel, that's how New Delhi feels, right? That's how New Delhi is deciding the lives of 1.3 billion people. And I guess we have our constitution to blame for it. That in 1950, the country decided, back then I guess it was appropriate, that we need to centralize power in one city. There was a loose India, princely states, normal states, some states like Goa that didn't become part of India till 1961, 14 years later when Nehru finally said, I'm sending an army. So I guess power needed to be consolidated in New Delhi to show the world and to show the 300 million Indians that it's one country. But now, in 70 some years, I guess the country should realize that we can't run a 1.3 billion person country from one city. And what surprises me about all the court backlogs in India is that I can understand one judge, one court, one city, one district, one state being behind and not doing what needs to be done right, which is very simple. And the hardest things to do in life are the simple things. But what surprises me is that, okay, it's not just one court or one city or one state, it's the entire country. It's like all of the judges, all the courts, everybody is thinking the same way, which tells me that the power is not with the state capitals or the district government and or local courts. Now, in other countries around the world, the law in most countries is that a local judge can run his or her courtroom any which way they want to, and they can set up their own rules. As a matter of fact, in US where Brenda and I practice, we have to look at federal laws if you're in federal court. If we are in state court, which is where we are most often, there's state court laws, the California Court of Laws that we have to follow. And then in the county we are in, the district we're in, there's 3,058 counties in the country. Every county has some rules that are unique to that county. And then we're told, be careful, there are local rules. And what is that? The judge's rules. Every chamber, every courtroom has his or her own court rules. I will not take this pleading on 8:30. I'll take it on 9 a.m. This matter I'll only hear on Wednesday, and you can't do this in my room and this and that, right? So this one sentence that, hey, judge, you're a judge now, you're responsible to make sure that this country is being run properly, set up rules that work for you. And one of the first court appearances I made, 8:30 a.m. downtown LA, one of the largest courthouses in the world. It took me 15 minutes to find parking and I was late by 2 minutes. I enter the court and the judge says, oh, are you here on this matter? We're hearing it right now. I said, yes, Your Honor. Okay, come on up and discuss the matter. And matter gets over in 3 minutes. And the judge says to me, counsel, you were 5 minutes late today. So before you leave, please write a check of $250 to my assistant to the courthouse. And the courts collect thousands of dollars, if not millions, in penalties against lawyers for misbehaving. So there's tremendous respect and fear of the judges, absolute fear for not doing things properly, forces us to do things properly. So Nandgopal, I want to ask you, let's talk about alimony and let's talk about 3 or 4 instances, 3 or 4 hypotheticals, and you can make up the hypotheticals as you go along in your answers. Let's say there's a rich couple and both husband and wife work and they have lots of property and some kids and they both earn in, let's say, an equal amount of money is one hypothetical. The other one, the one spouse doesn't work. The third hypothetical, they're both middle class and one spouse works but makes half of what the other spouse makes. And the fourth hypothetical, both spouses are lower middle class or kind of poor. So given these 4 scenarios, and feel free to make up more, give us a sense of how alimony works in India. Mute.
So far as alimony in India is concerned, the thumb rule has been that both of them have to live in this similar financial status. If, to give you a very quick answer to both, if both of them are equally placed, then the alimony may be looked into by the court very seriously. If both of you are equally placed, where is the question of alimony? But even then, some alimony will be paid. It's not that it will not be paid to one of the spouses. That is, the woman will always get some kind of an alimony. That is one aspect is concerned. Insofar as a person who is earning more and less, the court will try to balance what is this disposable income, and on that basis, court will arrive at a kind of an alimony which is acceptable to both, which can be enforced. Ultimately, the court looks at, if I make an alimony of, let us say, in a man earning about, let's say a lakh of rupees or 100,000 rupees, if I say give the wife 100,000 rupees, it will not work. So what the court will do is it will try to find out what is the income which can actually be allowed as his free income, that is after paying for his medical and all the support systems and so on and so forth. And on that basis, the court normally makes an alimony, maintenance or alimony, as the case may be. Now, the beauty of this is that the system is very realistic in its approach. It is not what you call 3,000 feet in the air, but realistic in its approach. That is all I can tell you. Insofar as a person who says, I can't pay any alimony, the court will say, sorry, you have to pay alimony, otherwise your divorce will not be through. It holds the grant of divorce as a kind of a Damocles' sword over his head and negotiates the kind of alimony that is to be given. But we use this advantage or this knowledge of law when we help parties find a resolution to the dispute. So we ask them, look, you tell me what is your income, what would the court grant, and what are you willing to give? And in all these cases, it's parties always are more happy to say, well, even if it is little less, I don't mind receiving little less, because it is not going to be contested. There is going to be an award or a finality to the decree, and I can always enforce the decree. So people look at these kind of aspects, and when we do the reality testing in a dispute resolution, parties do come to some kind of a conclusion.
Okay. And what about child support?
Child support is unquestionable. If both of them are earning, they are equally the Supreme Court has taken a view that both of them are equally liable to pay for the child's support. That is number one. If the wife is not able to support, then the father is always has to pay more insofar the child support is concerned. Or if the wife is earning more than the husband, the wife will have to pay for the child support. The husband will also have to pay, but a much smaller quantity. Because the word which is used is not husband and wife, the law which uses the word spouses, which could be either. It could be masculine or feminine gender.
Okay, beautiful. So I was going to ask you a lot more questions, but we're getting so many questions from the audience that I'll take a break from my questions and give preference to the audience. So Brinda, here's a question for you. What happened we got married in India, now we're living in the US. What happened to the dowry, the car my parents gave to the boy's parents, and gifts and money, and how do I get that back?
Okay, so if the divorce is filed in the US and you got married in India and you did all the dowry and the gifts in India, there's no provision in US, specifically in California is where I practice. There's no provision to get your wedding expenses back, but there's a provision to divide all assets and debts 50-50 and do alimony, child support, and attorney's fees as well, when one party cannot afford to pay their attorney's fees. But there's nothing about wedding expenses that I've ever seen. And we've always had that argument. We've always tried to do it, but we've never gotten any success going anywhere with it.
Right. But the good thing is that most cases settle in the US. There's maybe divorce matters, maybe 99% settle. So in the settlement, we can do anything and everything we want. And so if somebody paid a lot of dowry, then the settlement is happening. We're certainly going to make a big deal out of the dowry and try to get as much of it back as possible, or threaten them that we will not settle, and then they have to spend hundreds of thousands of dollars in attorney's fees if the case gets nasty. I remember doing this one divorce, and we represented the husband, and the opposing counsel who represented the wife. I finally said to him that, okay, it was a short-term marriage. I'm feeling bad this happened, and fine, I'll settle, I'll pay. There's no kids, there's no alimony, there's no child support. But I feel bad that my client imported the wife from India and got married, and So I'll pay you. Let me start with the marriage expenses. I'll tell my client to pay the wife's parents' marriage expenses. So I get a bill of marriage expenses of $30,000. And I look at the bill and shrimp is $1,200. So I call the opposing counsel and I said, hey, fine, I said I'll pay the marriage expenses, but it kind of seems inflated. And what is the shrimp of $1,200? So I'll never forget his answer. This was 20 years ago. And he said to me, I checked with my client. He says it was a large shrimp. I said, okay. I said, fine. So we paid the 30,000. Okay, next question, Brenda. Family says they have properties in India, but nothing is in the son's name. And so the parents are sitting on all the property and I'm not getting anything from the divorce.
So we need to know a little more about this case. Is this filed in the US? Because it's not very clear from the question. Okay.
Yeah.
So if the case is filed in the US and the husband's properties are in the parent's name, one thing that we could do is file a motion for joinder and add the parents to the action. And we just have to serve summons to them through the Hague Convention process in India, which in itself is a big mess and headache. It takes like a lot of months to do that. But once that is achieved, and there are some judges who will only accept the Hague Convention proof of service, and there are some judges that will accept a personal proof of service. So if we are lucky and we can get away with a personal proof of service, I feel like maybe adding the parents to the divorce action can help. And of course, we can do discovery and trace all the financials and all these deed transfers.
Right. So Dhruti and Mr. Nandgopal, let me ask you, if one spouse does not have money to seek a lawyer, what do you do for that person?
For me, I would just answer. For me, I would be taking a pro bono matter if the case is genuine. For example, even if a male comes and says, I'm harassed and domestic violence on male, I would say, I don't mind. Though you're coming to me, I'll do it pro bono. If there's a domestic violence on female, for example, this is a hypothetical example. I don't mind doing as a pro bono. But we also have legal aid services where they can approach if they want those facilities from the courts also, where they have legal aid panel lawyers who can assist them. Or we also have NGOs where people work for this sort of issues, wherein parties get lawyers at a reasonable cost fees or maybe no cost fees also who work for them. So it is very good to take up such cases, because I would like to share my experience in pandemic times in COVID-19. I got a lot of calls pertaining to this for free pro bono help and assistance on calls, advisories, etc. So obviously we need to help people at times in our profession, so we go ahead and help. But if there is a commercial note needed for our fees, we cannot let that go every time. Otherwise we will be just a free pro bono lawyer, which will not help us survive.
Mr. Nandgopal, what do you do?
It all depends, sir. Normally people, the summons from the court itself says that if you're a woman whose income is less than, let us say, I think 60,000 rupees annually, you're entitled to a lawyer to be appointed by the Legal Services Authority. All she has to do is take the summons to the Legal Services Authority, and the Legal Services Authority provides her with a good lawyer. Now, there are many of us who are also on the panel of Legal Services Authority, where the matter is referred to us and we do it on a cost basis, which we charge the Legal Services Authority. That is how the system works in Karnataka and in Bangalore. I don't know about the other states, sir.
Can't the judge, if the wife doesn't have any money, can't the judge tell the husband that you pay the wife's fees?
Normally, it is also ordered that legal expenses is what is an application is normally filed, that I am unable to hire a lawyer. But lawyer like Dhruti Kapadia is going to be very expensive. So if somebody says, no, I want her to be appointed, then I'm afraid the lawyer is already filed for bankruptcy. So it all depends.
No, may I add to this? Because I really interestingly want to add to this. Lawyers like Dhruti Kapadia would always work for good services first and then commercial services. So people can afford me.
Dhruti, if I were you, I would double my fees.
But back to the matter is the court does order legal services. Sorry?
We also have court legal aid. I'm also on the panel of it. So we do help people when it's in high court.
But the court does order. The court does order, sir. Court does file an application.
So for women, services in high court is pretty available, so there's no difficulty for anybody. But it comes to family court, it's a little different role there, because in mediation counseling centers, sometimes the matters settle. So then the litigation process is secondary.
But you're right, sir. The court does order a legal fees to the other side.
Brenda, you get asked this question often. People come saying, I don't have money. All the money is with my spouse, husband, whatever. What do you do?
Yeah, so I get asked this often from people who are stuck in India or left behind by their spouse in India and have just been served with a divorce and they don't know what to do and what their legal rights are. So here's the good news. Most states, almost all states, and particularly California, Texas, New York, New Jersey, Atlanta, Virginia, all of them say that when there is a significant disparity of income between the parties, the party who earns the higher income has to contribute to the other party's attorney's fees. Now, a lot of times people ask me, what is that magic number? What is the percentage of fees? So that really depends. Again, family law is a very personal practice, depends which courthouse you're in, which judge you're in front of. But I've seen judges award from 50 to 60 to 70 to 80% of attorney's fees for the wife. So that is definitely a good thing, because US always ensures that everyone is at equal ground so that they can fight for their rights and they can get what is legally theirs. You're muted, Navneet.
Okay. I remember many years ago, an older gentleman father called me from India saying, my daughter's getting divorced. They recently got married and it's not working out. Can you please tell us what to do? She doesn't have any money. I said, don't worry about it. We'll do it without money and we'll ask the court to ask the husband to pay. And worst case scenario, if we don't get the money, we don't get the money. We'll handle the matter. He wouldn't believe me that some lawyer would do this for free. And I said, I'm not doing it for free. We'll get paid. Don't worry. So he said, send it to me in writing that you will not charge me. I said, OK, fine. So I sent it to him in writing. And then I called up the husband and I said, hey, we're filing for divorce. He says, yeah, I know, we're not getting along. And the guy was an engineer at some company. I said, listen, she's leaving, but I need money for her to go back. And she's not from a very rich family and she spent $10,000 on the marriage and going back and this and that. And I need for you to pay it. And he got mad at me. And I said, OK, fine, you can get mad. I will file for divorce and you're going to have to hire a lawyer and fight this thing. And that's going to be 20, 25, 30,000, 40,000, whatever. Or you can pay the 10,000 and her marriage expenses and her travel and off she goes. And I'll do your divorce for both of you, husband and wife, and sign on pieces of paper and let's do this in a fair manner. He says, OK, let me think about it. Call me the next day saying, fine, I'll write a check at 10,000. Will you do the divorce for me also? I said, sure. And then I called the father back. I said, you were worried about that. I'm not going to charge you fees and you're going to have to pay. Here. I'm sending you a check of 10,000 minus travel and this and that. So can you what are the provisions for similar provisions in India, if any? Nandgopal, Dhruti.
So far as alimony is concerned, mutual consent is always an available road to file a petition for divorce, whatever the numbers that are agreed. But since the legal services as such is still fairly cheap, there are many lawyers. So, threat of legal proceedings is not really an effective way of negotiating insofar as India is concerned. Because you see, there is still a lot of rancor and venom against each other. They don't mind dragging each other in a court of law. And this is especially insofar as many men are concerned. They said we have to teach her a lesson. This is what happens. This I'm saying very categorically, but this is the unfortunate situation that there is no realization of what is in their best interest. And it is more so even with the women. Women do feel that they have been wronged, A, by the parents, B, by the system, and C, a kind of a little bit of self-sympathy for themselves. So this is the kind of a thing which kind of prevents people from very quickly finding a resolution for their disputes insofar as matrimonial jurisdiction are concerned. Yes, the moment they file a petition, they go before the court and say, look, I want this amount of money, that amount of money. The courts will say, all right, we can only give you an interim alimony, we can't give you a permanent alimony. But only in a mutual consent petition, all this can be resolved and put to force, and parties arrive at a settlement.
Yeah, may I just add to this? What happens, I'll tell you. In an alimony process, now we have a simpler rule that where affidavits need to be disclosed in the court. What are your assets? What are your earnings? And what are you getting yearly, etc., etc. And what are the properties you're holding? So this becomes transparent, as in you cannot stress somebody to pay you more than what you have, or you cannot really ask for more than what the person has. So this is something good which has come forward. Secondly, when it's children's education, medical health, etc., court is more considerate okay, who's going to keep the child. And if the woman is going to keep, then the education fees, etc., also becomes part and parcel of it. So that is again case to case, but alimony just for extorting somebody, that will not be permitted, because only 25% to 30% of the person's earning income, if the wife is not earning, can be given to her as an alimony. Maybe permanent one-shot alimony or monthly alimony, depending on case to case what is asked. So nobody is going to be robbed off with the alimony forums, as we rightly say. It's just a pressure tactics. But best skills is to negotiate and end with a mutual consent on it, because usually party wants to separate, but their egos hold them back, and they're like, we'll keep fighting. That's the problem.
So Dhruti, what do we do with, there's a lot of instances where people have their own business or whatever in India and they're not reporting 100% of the income. So what do you do when you have to get alimony from a person like that? I
will give you another example, sir. I know cases where guys hand the women, they don't keep properties in their name. They keep it in their family's name because they know the proceedings are going to do. So prior to the filing of the proceedings, they already pre-plan all these things. But now, if that is done prima facie, we always have the tax income, IT reports, etc. We also have those accountancies. Most of the cases are very unfortunate because women don't know what are the accounts their husbands are holding. So they are like, we don't know which bank it was in, which was it in. So, then that's where they lose out. Therefore, this affidavit process, which has come up now, is going to be very helpful. So nobody can hide it. Nobody can wipe it off. This is what I think.
One can always summon the income tax records, sir. From the income tax department, you can always file an application before the court and ask for the court to summon those income tax reports. That is number one. Number two is that if there is a suspicion that somebody is holding somebody else's property, the word which we use is benami. Benami means undisclosed. Benami. There is also a law which says that if you're holding the property for somebody else, you can also identify who is the actual beneficial owner. That can also be tracked down. That's not very difficult. But it is a process that will take time, and you'll have to convince the court to issue the summons to the income tax department to do the discovery and get it to you.
It's a tedious process. It's not immediately foundable.
It is a tedious process.
They transfer it before the litigation. So then they're like, now we don't hold anything. Now what she wants from me? This is what the man stands and says. This is what the woman will say. I earn nothing. I've left my job because I'm married to him. I need alimony. Because most of the times in India, sir, unlike in USA, most of the girls have stopped actually working full time. Because they are like, we want to take care of household as well as. This is not true fact, I would say, but in many of the cases, they feel like, I know the instances of cases where women have said, we are MBAs, but we are not working because our husband wanted us to join their business. For example, part-time business. So what they want to achieve has not been always the case. And that's why they're like, we've lost so much of our income. Therefore, we want so-and-so alimony from this person. So now if this is to be proved, then this guy comes up and says, she was doing my business and she was enjoying this. So it's case again. So, sometimes independent women will not be in a position to claim anything because she's earning more than what the man is earning. So that's again case to case when it comes to it.
So Dhruti, about a year ago or so, the Indian government put in a law banning triple talaq, right?
Yes.
So a guy can't say talaq, talaq, talaq 3 times and get divorced. How is that working out practically since the law was passed?
I'll tell you one thing, sir. I would respect the law. I will not say anything which is passed. But what is not really practically helping in this case would be that a person goes behind the bars, if at all 3 years punishment, but the divorce doesn't become invalid.
Why?
May I comment?
Yes, please.
Insofar as triple talaq is concerned, the question of the law recognizing it as a valid divorce is now completely eclipsed.
Both together, I can give an expert opinion on it.
Sure.
Yeah. What I wanted to complete, sir, was that it is not many cases that's come forward to ask for it, because Muslim law, personal law is a very, very expertise field, and not very fast would a person come for it because they try to resolve it internally. It's too new right now to get a catch hold of too many cases that we can really weigh it to what level it's working out well. But I'm sure if the legislature is made, it would be beneficial for the society as a whole.
So if somebody tries to do a triple talaq, then they can be put behind bars?
So as of now,
Sir, you can complete.
Yeah. See, as of now, sir, insofar as the law recognizing triple talaq as a manner of divorce is now completely eclipsed by that particular judgment. So no longer the court recognizes it as a valid form of divorce. In addition to that, as a deterrent, a person can be put behind bars. This is something which is a part of the law. That is number one. Number two, this has led to a very peculiar kind of an anomaly amongst the Muslims in India. That is, one is a man can now no longer file for a petition for divorce because it goes back to a very old act called the Muslim Women Right of Divorce Act. Now, there are certain clauses in it under which it's only the woman who can file for a divorce. The only other form of divorce which is recognized under law right now under Mohammedan law is what is known as a kulla. Kulla means a release because, as you are aware of, Mohammedan law marriage is more a contract, and the contract can be only broken by consent of both the parties. Now, previously it was a unilateral consent by triple talaq. Now it is no longer. So it could be either kulla, that is the wife can ask for a kulla, and that means a release from the marital obligations, which means that she forfeits her rights to what is known as a meher, which is a kind of an alimony which she agrees at the time of the consummation of the marriage or at the time prior to the marriage. That is number one. Number two is she can already go to she's the only person who can go to the court and ask for a divorce on the ground that these are the instances in which he has treated me with such amount of cruelty that it is no longer safe for me to go and live. Now, this has led to a peculiar situation where the husbands, whatever happens, the men cannot approach the court for a divorce. It is only the women who can approach for the court for a divorce or recognition even under the statutory law is concerned. This is the kind of situation that we are in. Hopefully, this will be changed and this will be addressed to by the Parliament, but I don't know when that would be done, sir.
The reason why these laws were necessary, I would just say, because many times there was a very unjust situation where with this.
I agree.
Yeah, let me just complete, sir. Because many times women were not in a position to fight out. They were like, this is what has happened, we are trashed off. Legislature has tried to protect the women, but penalizing it, I would say, would not be the ultimate solution, though 3 years jail is given, just a threat thing that you will go behind the bars if you continue this would be an offense. But the validity of the divorce and to make it invalid and make it like, dropped off would be a better solution. That was my view in that. Because today also, see, when a man tells you that, look, I don't want to live with you, say it, forget Mohammedan law, say it Parsi law, say it anybody, Special Marriage Act, or a woman says, I don't want to live with you. You cannot force somebody to live with you in a practical sense.
Right.
That's why we discussed about restitution, we discussed about the talaqs, divorce, the whole rotations of the individual emotions and choices matter in the matrimonial laws.
Dhruti, I will only answer this question to you since you have raised the question. I'm sorry, this might be going off the subject, but the only reason why this has happened is that most of the times polygamy is an accepted norm amongst the Muslims. Now, what would happen is a woman would be given a triple talaq and immediately the man would rush into another kind of a marriage. And this woman would be left high and dry other than what she was entitled to, what is known as the period of iddah. She was entitled, what the period of 90 days after the divorce is granted, she would be entitled to maintenance. Afterwards, she would be thrown onto the streets. If you remember the Shabanu case, that was the whole issue. She filed a petition before the court and which kind of led to such a huge anomaly. Now, the only time it has got corrected is only recently. The triple talaq is not accepted, though the polygamy was also a question before law. The Supreme Court has not commented on it, which I don't know why. But I mean, I believe that it is a part of the personal law of the Mohammedans. They don't want to comment about it. But this is how the situation is. The anomaly is that we are faced with a situation where women had no rights at all because the man would send an SMS and saying, I said talaq thrice, and the matter would be over.
In short, so there was a validity triple talaq, but it was being misused by Skype.
No, he would say, I said it in the presence of somebody and send a WhatsApp message, the divorce is granted. It was supposed to be recognized under law. This was the situation which led to this particular situation. Something which we'll all have to think about.
Just to summarize, sir, any law in India can be used, misused and abused. That's it.
Okay. Well, in the judicial ranking of the 200 countries in the planet, India is ranked number 62. So I don't have a problem India being ranked 62 or 100 or 50 or any country being ranked as 200 countries. Somebody's going to be number 200 and somebody's going to be number 1. But in happiness, India is number 42. In ease of doing business, India is 127. In judicial ranking of only 100 countries, the other 100 countries don't have law anyways. So the judicial rankings only of the top 100 countries, and India is 62. In Human Development Index, which includes salaries, compensation, liberties, law, India is 130 something. The problem I have with these big numbers, 62 and all, is that India is not a tiny country, is not Vatican City with 200,000 population. India has 1/6 of humanity. 1 out of 6 people in the world live in India. So when a country like India gets a ranking of number 62, then that tells me that majority of the world, the 61 countries ahead of India, have access to a better legal system than 1/6 of humanity. And unfortunately, that 1/6 of humanity is us, Indians. That bothers me more than anything else. So, Brenda, I have a question for you. Husband, wife, 2 children come to visit to India. Husband goes back to USA and takes the wife and kids' passports with him. Now the kids and wife are stranded in India, and the husband comes to USA, files a complaint against the wife for kidnapping, and files a complaint for missing kids. What can you do?
So this depends on whether it was filed in criminal court or in family court. Wherever it was filed, it's important to file your response. And like I just said, that the law does provide for attorney's fees when there is a disparity of income. And you can also ask for sanctions because this kind of conduct is sanctionable. So you absolutely must file a response in the court. Otherwise, you'll always have an abduction charge hanging on your head. And anytime you come to the US, I mean, you could potentially get arrested from the airport. So you don't want to risk that. You definitely want to answer that. So you must get in touch with an attorney who can help you with this and address the situation. And don't worry too much about attorney's fees because like I said, your spouse can pay for the attorney's fees. You can ask for attorney's fees and costs and sanctions. So it's definitely something that you should do and not just sit over.
Is it true? Is it true that every divorce in not every, but most divorces in US, the spouse that doesn't have money, the first thing the spouse who doesn't have money, their attorney does in court is file a petition asking the judge to order the other side to pay his or her fees?
You know, that's what should be done, but not all attorneys do that. So I think that's my first question to every client, that what is your financial status like, and how much of a fees they can afford or not. And what I like to do as good practice is, when I file the petition for divorce, or if I'm answering a petition for divorce, I like to file the motion for spousal support, child support, and attorney's fees. And mind you, this is not like only one application that you can make for attorney's fees. You can make attorney's fees motions throughout the pendency of the case. And you can also get attorney's fees at settlement and at trial.
Great. Yeah, it's a good thing about the legal system. You represent a rich couple and the wife doesn't work and doesn't have access to money. And so first thing we do if we represent the wife is file a petition in court asking for attorney's fees. Basically, you go to the husband's house and knock on the door and say, hey, we need some money. And the guy says, what do you need money for? And we say, I need money to buy bombs. And then the guy says, what do you need bombs for? So then the answer is to throw them at you. So it's very simple. If you're gonna not close the bank accounts and close the ATMs and not let your wife have access to money, then for her to get equal justice, she's entitled to money and California's community property. And by the way, the 41 states in US that are not community property, from a divorce family law point of view, they kind of behave like it is a community property, most of them. So I know we've gone over. I have dying to ask Mr. Nandgopal one final question, and hopefully the audience will pardon us for going a bit over. So Mr. Nandgopal, don't you think a country with 1.3 billion people, that the states should now ask the federal government to make judiciary and law a state subject, or at least a shared territory, that state of Karnataka can do whatever laws it needs to do to fix the judicial system and be the first state in the country to not have a backlog?
Let me answer this question to you, sir. One is that the states, insofar as the lower judiciary is concerned, it is the state subject and it is the state that manage everything. Now, under the Constitution, there are three lists, which I'm sure that you are aware of: the state list, the central list, and what is known as the concurrent list. So whatever laws that each has got, they have become the absolute masters insofar as that particular jurisdiction is concerned. So we already have that amount of bifurcation. Now, insofar as judiciary is concerned, the higher judiciary, that is the High Court, that the appellate high courts and the Supreme Courts are directly under the Constitution, appointees under the Constitution, which means they are federal courts, really, if you really look at it, because the salaries come from the Consolidated Fund of India and they are appointed by the President. Insofar as the district judiciary is concerned, they are appointed under judicial service of each state. So to that extent, yes, we already have it, and we are moving in that from a very long time, I think ever since the Constitution is concerned. And each state can also legislate in so far as the list, or rather areas, subjects which are specialized in the state central list. But only thing is, it needs to receive the assent of the President, which means that law will override the central law. We do have it, but what has happened is, unfortunately, is that we have had a system of having one too many holidays, because we were still very colonial in our hangovers. We are like school kids, having a summer recess, having a winter recess, having some other recess. We have more number of holidays, and I think out of a 365 days, we work for barely 160 days, which is ridiculous. So to that extent, let me tell you that during the period of COVID, I think Karnataka High Court and Karnataka courts have disposed of far many more cases than one can ever think of. So from the judge friends whom I know, they are looking at it to make it permanent. Even today, I can appear in the High Court sitting from my chamber. I don't need to travel there. I can opt for either a video conferencing submissions before the court, or I can actually physically go before the court. And people from all parts of the states are doing the same thing. I can do that in the district judiciary. I can do that in the family courts. So, the thing is, this is getting streamlined. I think over a period of next 1 or 2 years, I think we will be able to bring down. And anyway, an average litigation in Karnataka does not last more than about 2 years at the outer limit.
Oh, wonderful. That is superb. I'm pretty convinced that COVID is God's way of fixing many maladies of the world: environment, pollution, petrol, traffic, time wasted. 50% of petrol is wasted in India because the cars are just sitting there in traffic stuck. And then people in villages, small towns that have to run to Bangalore and for courts, now they can do this on Zoom or video or whatever. In a lot of ways, a lot of problems of the world are getting solved. So I'm sure there's some mastermind behind the COVID.
Technology has helped even the Bombay High Court, even the Supreme Court. We've been sitting and just arguing matters, and disposal rates have been faster. We must thank our E-Committee of Supreme Court and all the judges who have really participated to learn this, because nobody really knew how to do this. Very few knew. Out of 100, at least 20 would know, but not 80 knew. But everybody accepted this challenge. So it's always a blessing in disguise. I would say COVID pandemic taught us this technology, otherwise would have been laid back, though we all knew a little bit about it, but it did not really function. Arbitration, international arbitrations, I can sit and do sitting home. I mean, this is wonderful and people accepting it.
Yeah, Dhruti and Mr. Nandgopal, I want to tell you a secret. Thousands of courts in the United States, thousands of judges. Every court now has wonderful technology. And everything is, a lot of stuff is getting done on the internet, and every court software and technology that is being done in the United States, there is a person from either Hyderabad or Bangalore or Chennai or Delhi or Mumbai. So if these guys can fix the technology in the courts of the United States, I'm sure they can do this of India as well.
Sure, I'm sure they can, and they are doing a pretty good job at it.
We'll see India prosper with technology quite a lot because people are already open-minded now. We have to do it. It was not like we will do it. It's have to do it, and we are doing it.
Brinda and Dhruti and Mr. Nandgopal, it was one of the best panels I've ever had an opportunity to sit in. You guys were just awesome. We'll have to do this again. Thank you so much. I know I took a lot of your time.
Thank you so much.
Thank you.
I had pleasure to Nandagopal sir, with Brenda Gandhi sir, Madam, and even you sir. It was interesting, and my audience here who has heard us, I hope they've understood whatever we could convey to them, and hope we will also learn from their queries, and we'll do our research if we missed out something.
Thank you.
Thank you very much, Mr. Navneet, Brenda, and Dhruti. It was wonderful participating. I hope we've been able to answer some of the questions. I'm quite sure there will be some more questions, which we will have to take it by the time they come up. Okay?
Sure. Let's do it again.
Pleasure. Let's do it again.
Thank you so much. Thank you so much.
Thank you so much,
Deepa and Francesca, for helping us. Thank you.